do a little slower than you.
Welcome to the third and final panel of the day, which is on law and technology. My name is Jim Park. I'm a professor here at the law school. I teach classes in corporate and securities law. In some ways, you might think of law and technology as in conflict with each other. Law tends to be conservative. It tends to say no. Technology tends to innovate, and it tends to push the boundaries. And so under one view, we might think of law and technology as being somewhat antagonistic to each other. On the other hand, I think that law is much more flexible, I think, than is commonly perceived in many respects, and that law has innovated and changed on its own, and in many different contexts. And so there is at least I think that the flexibility of law, I think, is something that is underappreciated by non-lawyers. And I think that we can touch on some of those themes with respect to this panel. And so because it's such a complicated relationship, we have a very diverse panel from very different perspectives. We have a couple of attorneys, we have an investor, and we also have a law professor to discuss these issues. I'll let each of the panelists introduce themselves, and I've asked them all to tell the audience a little bit about what they do, especially for the benefit of the law students in the room, and to talk at least initially about some of the interesting technologies that they've encountered in their work that they think are going to be significant. And so with that, I'll turn it over to Mike Heath from the Gunderson law firm.
Hi, my name is Mike Heath. I'm an attorney with Gunderson. I've been there for 10 years. Our firm, for those who don't know it, is primarily focused on the emerging growth market, so very much focused on the startup and venture capital market. We don't do litigation or any real regulatory practice. I think the technology that I'm seeing that changes the way that a lot of people think about their businesses is decentralization, call it blockchain, call it crypto, whatever you want to call it. It opens up all sorts of very kind of thorny questions about, from a regulatory side, from a social side, from a policy standpoint, as well as from a securities law side for some of these projects. In addition, I mean, my core practice is really kind of a venture financing practice. So I work with consumer products companies, enterprise SaaS, companies that are trying to fire cargo through pneumatic tubes. I mean, kind of you name it. If people can think about it, we work with those sorts of companies. So I'll turn it over to Shahin.
Thank you, Mike. My name is Shahin. I'm a partner at a venture capital firm called Lux Capital. We do early stage private company financing. We do everything from a couple $100,000 checks to help get companies off the ground to $15 million to lead early financings. Our philosophy is to back great founders that are leveraging some kind of unique technology to go out there and build and dominate a massive market. We've invested in over 130 companies over the course of our 5 funds. Our current fund is a $400 million fund, and we have a total of about $1.5 billion under management. I actually did my PhD here at UCLA in electrical engineering. I wandered to the north side of campus, and I ended up doing a minor at the Anderson School. That's when I learned about venture capital. And I started a company naively around my research here at UCLA. And it was a great example of a cool gadget that was a terrible business. And I was told the best way to get to know VCs is when you don't need their money. So while I was thinking about my next startup idea, I reached out to a bunch of VCs. One of them was Lux Capital, and they were kind enough to give me a shot at being a VC. So I thought I'd do that until I figure out my next startup idea, and here I am 12 years later. So I've led our investments in rockets, science, satellites, driverless cars, manufacturing automation, robotics, computer vision, and as a firm we've invested across healthcare and technology. We do not invest in social, local, mobile, find a date, find a parking spot, rent your couch, get a beer delivered to you. We don't do any of that kind of stuff. To the question that James posed, I'm very excited about autonomous cars. We've made a very large investment in an autonomous vehicle company called Zoox, and we can talk about that later, but I think regulation has a huge part in accelerating that technology.
Yeah, so it's a little depressed that Sunnyvale, Mountain View, we're going to have driverless cars. They've been approved, so not a good idea yet. So my name is Nancy Wojtas. I'm a partner with Cooley. I'm in the Palo Alto office, Silicon Valley versus Silicon Beach, although we do have an office in Silicon Beach. I mention what I'm going to mention right now for a reason. I started my career at the Securities and Exchange Commission. So I started trading in markets. I was going to be a trader, and I figured, hey, in T-R-A-D-E-R, not a traitor, and got moved into the chairman's office. And really interesting for a kid out of law school, suddenly advising the chairman of the SEC on everything from enforcement cases to policy matters, and never looked back. I've been a public company lawyer my entire life. Cooley, like Gunderson, has a significant practice in the emerging company arena. We have about 6,000 emerging companies that we advise. And notwithstanding my background being a public company lawyer, it's impossible not to represent emerging companies. One of my emerging companies, about 18 months ago, messaging company, really having a hard time. The advent of Facebook, Snap, it's a business that's really tough, decided to tokenize its business. And I got introduced to blockchain technology and public token sales. One of my then partners, Marco Santori, big crypto guy, some people will know his name. I brought him in on the matter thinking, hey, I won't have to know really anything about it. And then kind of mid-2017 hit when the crypto market really, really took off. And we couldn't field calls fast enough altogether, doing really substantive work. So I and one of my colleagues took over the public token sale that my client was about to do. So learn from bottom up how to do these things. Blockchain technology is phenomenal. And people will say, well, yeah, the technology's okay, but cryptocurrency, everything's a fraud, including from a lot of my partners. I just made a presentation to my partners at the partnership meeting. But what people fail to understand is cryptocurrency fuels the technology. And what the SEC doesn't get, and I just came back from the SEC, and we can talk about that later, last night. So you'll have like firsthand information. I haven't even reported this to anyone. What the SEC fails to understand is bringing in the 80 years of history of securities regulation and trying to layer it on cryptocurrency just doesn't work. Cryptocurrency is trading in milliseconds. It can't do T+2, which is what a securities trade takes. And that's what the SEC can't seem to get in their head. And I disagree with James that, the securities laws are, can innovate. Maybe the law can, the regulators are not. And so I'll leave it with that, and we can challenge my hypothesis.
Hi, I'm Eugene Bullock. I teach here at UCLA Law School. My first career was as a computer programmer. I also got a degree from South Campus, although definitely not a PhD. It was a bachelor's in math computer science back in '83. So I worked for 12 years as a computer programmer. None of that really is necessary or even terribly helpful for understanding modern technology. I mean, this is, I worked from '80 to '92. That's a very different era. But what it does is it just makes one realize that one doesn't really need to know the tech. I think there's some people who are daunted by their lack of a tech background who shouldn't be. So I'm very pleased to be here at the Silicon Beach conference, although I never quite understood the name. All beaches are made of silicon. I do mostly First Amendment law. But I started out early on in internet law. My first article on the subject was in 1995, and I've been writing a lot ever since. I've also done some things on technology and privacy. I have an article on how tort law undermines privacy, even some aspects of it purport to try to protect privacy. And most recently, I have kind of a pie-in-the-sky futurism piece that's coming out in Duke on artificial intelligence and judging. But I have a somewhat more practical piece on law law and virtual reality and augmented reality that Mark Lemley and I just published in Penn just a few months ago. The technology I'm most interested in is virtual reality, which I think can be, it's going to sound grandiose, but I think it is civilization-altering technology. I think it'll change work, it'll change social life, it'll change family life, it'll change the patterns of human settlement, it'll change how we understand education and tourism, and as well as, of course, entertainment and gaming. So those are important enough as they are, but I think those are just the tips of the iceberg. So I'm really excited about VR. It's not there yet, but I have hopes.
Well, since we have a couple of experts on blockchain, I thought I would start there and direct a couple of questions to.
Everybody's a blockchain expert nowadays.
Although every
I get
perhaps
so many LinkedIn requests from blockchain experts, crypto and blockchain.
maybe all of us are now in the blockchain, if you will, and so I thought I'd direct a couple of questions to you guys. First, Mike, what sorts of blockchain products are you seeing in Los Angeles? And the question that I've always wondered is, the SEC had signaled to some extent that ICOs are securities and that it would take a hard stance with respect to the technology. And so how are we still seeing so much activity in this space?
Great question. So in LA, I mean, you really run the gamut. LA is fortunate that it has some very high-profile developers and backers of these projects, as well as investors. And so there's a really, really great economy here, particularly around Santa Monica. And so it runs the gamut from what some people call utility tokens or software tokens, and these are designed to create decentralized networks, to people who are, I saw one person who was trying to build a decentralized ISP that would enforce net neutrality through its protocol. So some very, very kind of big ideas. I mean, these are very hard to get up off the ground. You have to hit critical mass, but there are some very big ideas out there in the LA market. On the other side of it, you see people doing straight up securities offerings as a token, which is a little bit more cut and dry, a little bit more you can kind of color that inside the lines a little bit more easily. As to your question as, how are people doing these ICOs? I mean, I think in 2017, as Nancy mentioned, June 2017, it was just kind of, the idea was that rules no longer apply and people were running full speed into a brick wall, and they were just going out and doing these token sales. They would put out a white paper, terms of sale, and then it was just, hey, and now send your ETH to a smart contract and we'll send you back an ERC20 token. Or if they were building on, not on Ethereum, it was, hey, we'll send you back a token if you just tell us who you are. There were no know your customer checks, no anti-money laundering being done, and there were some very, very large offerings going on at the time, $100 million, $200 million, $300 million offerings. Cooley actually, in August 2017, I want to say it was, working with a company called Protocol Labs, decided to kind of take what the SEC had said about be careful, securities laws probably apply here, and pioneer kind of a pre-sale model where the pre-sale is done in a securities compliant manner, and then the idea being once the network is up off the ground and running, you can settle that derivative contract into a token, and then that token can trade freely without any reference to the securities laws. And Director Hinman at the SEC has given a speech back in June, and then just kind of reiterated again last week in New York to the Tech GC conference, that he does believe that there are tokens that are not securities, and that there is a model to fund these projects without violating securities laws. But kind of his position is the vast majority of these things still are securities offerings, which means you have to comply with all of the securities offering rules. Director Hinman's opinion is that you should be funding these businesses through kind of a conventional venture financing model, and then once the technology is up and off, kind of you can stand it up, then you can kind of move on to the next phase, which would be kind of a more public token offering. I think it is interesting, though, the SEC has not really brought any actions on a pure securities law violation. Almost every single action they've brought that I'm aware of has either involved material misrepresentations or outright fraud. And there haven't been, as far as I'm aware, any straight just violation of the registration provisions of the Securities Act to date.
There are about 80 investigations
Yes,
pending, which
there are.
quite a few of them are a pure Section 5 violation.
Yes, there are pending, but they haven't. But everything that's been brought to date has involved fraud. And I think because this is a global market, if the SEC is aware that if they crack down very hard here, it's just going to move to Singapore, to the British Virgin Islands, to the Isle of Man, to Gibraltar, to any of these other jurisdictions. And I think there is a real concern around U.S. investors being locked out if the SEC overregulates here. So I think, unfortunately, what we have right now is just, it's very uncertain. And the SEC is being careful not to go, too far in either direction. But the problem is that entrepreneurs who have to make decisions don't have clear guidance from the SEC on what to do other than you shouldn't do a token offering, you should do a venture financing offering and then do a token. That's the SEC's position to date, really, kind of on this stuff, I think.
So I agree and disagree in part with you. First, in terms of kind of interesting deals out there, right now what we're finding are the protocol layer. And again, when you think about blockchain, or the way I think about it is, it's the next layer of the internet. And that's why it's so exciting. It eliminates the centralized authorities that control us right now. The Facebooks who control our personal information, the Googles, the Amazons, it is a way to lose the control that they have over our lives. And it is done because of this distributed network. You will be able to control your own identity. And because you're able to do that, you will be able to earn money if, in fact, you want to share that information, whether it's through advertising, whether or not it's your health information, if you're a part of a clinical trial, whether or not it's 23andMe, your genetic material that you want to keep confidential. You don't want it reported to all criminal sites. So it's a way to, in my view, kind of democratize the economy. And so we're seeing a lot of really interesting projects. It's also, to me, tokenizing a business. It's really interesting in the gaming business. And I've always liked kind of video games, and we're seeing a couple projects that actually make a lot of sense that I think, well, we took one to the SEC who's still thinking about it. So let me get to the SEC. So in December of last year, the SEC, who had remained relatively silent, and one of the reasons we went out with our own white paper to try to provide a structure around these transactions that we were seeing, in effect, tranching the transaction, the pre-sales, they were securities. Securities lawyers all agreed with that. Something called the Howey Test. We all understood the investment contract analysis. I've had the conversation with more developers than lawyers on the Howey Test, which is really kind of phenomenal. I took a test of just internally asking some of my securities litigators. I said, do you know what the Howey Test is? And, no. So developers know it, my securities lawyers don't. We kind of introduced that framework, and what we talked about in the white paper said, look, there's no black and white test of when that network is functional. And we talked about perhaps maybe at the minimum viable product stage, as long as the token could be used in the network, we believed, hey, not a security. The model was pretty much universally accepted, whether or not they called it a SAFT, a simple agreement for future token, which irritates the SEC a lot, that title. So, I had a conversation with them. I said, look, let's just call it a purchase agreement. And it's like the blood pressure drops. So that was out there, and people were utilizing that model. And I think people were taking it a little too far in terms of when was that network developed that the token could be used on. And finally, in December, the chairman came out and said, look, I have not seen a token offering that was not a securities offering. And at that point in time, we stopped all of our clients from doing, well, we either told them to stop or we disengaged with them because we weren't going to be a party to a securities offering without proper registration. And, it kind of put everything on hold in that arena. The chairman came out to the Rock Center at Stanford, gave a speech, said, look, market professionals, we're watching you. And Andreessen Horowitz, I give them credit, they reached out to the chairman, they had a private meeting with him, and the chairman told him, look, form a small industry group, make suggestions to us how we can rationalize the securities laws with, what's happening in the token arena. So there's a small group, Andreessen Horowitz, Union Square Ventures, there were 3 law firms, Cooley, Perkins Coie, McDermott, Will & Emery, 2 educators, Joe Grenfest, who's a former commissioner, who's now at Stanford. We had somebody from Berkeley, and then we had NVCA. So we put together a safe harbor proposal where we, again, tranched each kind of segment and figured out how the securities laws would apply to each of those segments. The last one being fully decentralized network. It doesn't make sense that the securities laws would have any, application to that type of a network, like Bitcoin or Ether. And at the time in December, the chairman was saying Bitcoin was a security. So we had a lot to teach the SEC. So we submitted that safe harbor to them in March. We met with them. We met with congressional members. We met with Department of Treasury, the CFTC. The SEC told us, look, we're the government. It's going to take years before we get to a safe harbor. What we suggest you do is start submitting no action proposals to us, which a no action letter is something you describe the facts, you provide the legal analysis, and the SEC will say either we won't recommend that we go to enforcement with you, or they'll say you should withdraw this because we're really not going to be issuing that no enforcement comfort to you. So we put together a letter, we submitted it to them in draft form on October 1. We met with them yesterday. It was like talking to Amy. It solicited a lot of information out of us. They wanted us to explain it to them because our sense was they had not read the letter. And Amy was not, providing you any information. Neither did the SEC. And other than to communicate once again that they don't buy into anything other than a full securities law application to any type of a token offering. They view Bitcoin and Ether as being really very different. So what does that mean to entrepreneurs who want to do a token within their business? And what we are seeing right now is a couple models. One, and we represent investors as well as the entrepreneurs. In fact, we were on the other side of Gunderson. You were representing the investor. I think of a gaming one. And it takes a lot for lawyers to kind of come to grasp with everything blockchain provides you. It's different than doing a securities offering, and it's hard for lawyers to comprehend that. I view it all generation. It's a generation issue. Our summer associates get it like in 3 seconds. My partners who are my peers, they still don't get it. Their eyes roll over. So we're seeing the equity model. Investors will invest in an equity round, but there'll be a token component, whether or not it's a warrant to acquire tokens, either at the time the token is actually used or issued, or we continue to use the SAF model, which is a pre-sale of future tokens. What we are not seeing right now is the frothiness that we saw, obviously, in 2017. I mean, Protocol Labs, who co-wrote the SAFT white paper with us, they did a pre-sale and they raised about $250 million. Telegram, who raised billions through a private placement, neither of those companies have done a public launch of their token yet. So what we are encouraging entrepreneurs to do, and it's kind of a chicken and egg thing, to have a network that is fully decentralized, you got to get the token out there. And it's hard to figure out what's going to make the SEC happy. Even giving away tokens for free, in the SEC's view, implicates the securities laws, and you need to file a registration statement or have an appropriate exemption. We, again, disagree.
Thank you. It's a fascinating subject, but I'd like to shift this discussion to tort law, autonomous cars, and virtual reality. But I would like to make a plug for the Lowell Milken Institute. We're working on a policy report that analyzes a lot of these issues with respect to tokens and the SEC's approach. Hopefully it'll be out in the next month or so. But Shahin, you mentioned that you have an investment with respect to autonomous cars, and I was wondering if you could speak to that investment. What are the legal issues that you are worried about with respect to that investment, and how do you as an investor assess those risks that may not be apparent at this time?
Sure. So investors typically shy away from companies that face heavy regulatory challenges because as an investor, you're already taking a bunch of risk. There is product risk, technology risk, team risk, in some cases market risk. Taking regulatory risk on top of that is probably too much for folks to swallow. In this case, however, we made an exception in autonomous cars because the impact was just so massive. It seemed obvious to us that technology will mature to the point where a vehicle can safely pilot itself. And when I say safe, I don't mean zero accidents. I mean less accidents than the scenario where you have human piloted vehicles. And thankfully, humans have set that bar very, very low. We have 35,000 deaths per year, and so that's made it very easy for the engineers, easy I guess is a relative term, but possible for the engineers to build a machine that can perform better than humans. However, the ethical and legal issue arises where you are building a machine that can make life and death decisions. Now, the reality is that there are many machines around us today at the hospital down the street here that are capable of, in the case of a malfunction, can lead to serious harm to a patient. Our cars today, in the case of a malfunction, can lead to serious death or injury. However, these are malfunctions. These are not decisions. It's not like as if the vehicle is choosing for its wheels to fall off, or let's say the O2 tank, for example, in the ICU is not choosing to shut off. It is a malfunction that leads that to happen. Whereas in an autonomous vehicle, there are scenarios where the vehicle has to make the decision to either harm, let's say, one person or harm a car full of people or a bus full of people. Or, for example, harm its own occupant in the interest of not harming others. And so as humans, we are at liberty to make those decisions, but we are not accustomed to machines making those decisions. So the question becomes, how do we regulate that? At what point can we determine that a vehicle is indeed, or a machine is indeed qualified to make this decision? And there is absolutely no regulatory framework today to support that, unfortunately. We have the benefit of having the airline industry over the course of a couple of decades go from people trying to figure out how to fly to having commercial aviation. And so long as airplanes comply by certain rules set by the FAA, then in the case of a catastrophic accident, the airlines aren't sued out of existence. There's an investigation, there are disclosures that have to take place, those cost money, those take time, those cause harmful PR, but at the end of the day, it's back to business as usual. There is no similar framework right now for autonomous cars, and a lot of that has to do with the sensitive issue is how safe is safe enough? Are we willing to let a vehicle make that life or death decision? And at what point are we feel like as if a vehicle is ready to do that? I wish I had the answer to that, and I hope you guys in the audience, those of you who are students, at some point will work on this and help accelerate safer roads for tomorrow.
Eugene, do you have any thoughts on that, or do you want to talk about virtual reality?
Well, no,
Okay.
I'd love to talk about that because actually I think there are interesting tort law questions that arise with a lot of things, including with autonomous online agents. So first, I totally agree. It's always a question of compared to what. It's a mistake to expect perfect safety. The legal system, at least formally, does not expect it, although it may be hard to, once you're in front of a jury, to persuade them, although maybe not. I mean, juries are well aware of how dangerous human drivers are. And then on top of that, there is insurance. And, nobody likes to buy insurance policies, but the fact is that businesses routinely face risks that are completely uninsurable. The risk that people won't want to buy your products. That's why most businesses go out of business. You can't get insurance for that. Compared to that, the risk that there will be some number of accidents, that just gets priced in. So the interesting question is, the interesting point I think here is that it seems to me there are two questions. One is how safe is safe enough in the normal course of things? And I think one might say, if, for example, it's safer than a normal human being driving, then that's safe enough. Another possibility might be that especially as there are more and more such technologies out there, is it as safe as it could be given a reasonable investment, especially if there's some other benchmark that's better. So that might end up happening, probably will happen over time. Another possibility might be to say we don't need to say that especially when we're talking about two autonomous cars, and usually at first we wouldn't be, but eventually we would be, just have a pure no-fault regime. Why have the one insurer sue another insurer, one manufacturer sue another manufacturer, when you could just say, look, we're going to provide you basically with first-party insurance for your property and for your person, and thus not have to have adjudication. The tougher question is, what do you do in a situation where there is a deliberate decision that can be proven as such to harm somebody or to do something that will cause harm with a very high degree of certainty in order to avoid another harm? So the classic example is my driverless car is going down the mountain road. There's a pedestrian in the middle of the road. You can either hit the pedestrian or you can veer, but that will very likely cause the car to plummet and its driver and passengers to be destroyed. Usually when that happens today, first of all, you don't have as much evidence as you do with a driverless car, which records everything. And second, I think the reaction is humans being human. If I injure somebody, not out of malice, but because it's the only way of saving my life, that I end up being cut slack under various theories for that, although it actually turns out to be complicated, both a matter of criminal law and tort liability. But if sort of this third party says, because we were looking out for our customers, we're going to sacrifice the lives of pedestrians or other drivers in order to protect the customers, that's not a ridiculous position. And some jurors may appreciate it and say, well, that's what I'd like my car to do. But the question is, to what extent might that lead to either punitive damages or ostensibly compensatory damages where the value, which is always guesswork or a judgment call, is jacked up because of the perceived misconduct, to the point where either things become uninsurable or the insurance becomes so expensive that it blocks the development.
Can I ask you a question? You know more about this than I do, but does insurance exist in a regime of infinite liability, or does it only exist in a regime of finite liability?
Well, infinity is a very big number. In fact, it's so big it's not even a number. There are no regimes of infinite liability, it seems to me. And here the liability is pretty manageable.
You can't, like for example, the Toyota Prius issue or the Audi issue of the 80s. these were known as like neglectful, or the Dieselgate, for example, Volkswagen. I don't think you can insure against neglect or corporate espionage or fraud, or can you?
Well, it's not a matter of magnitude of liability. Neglect you insure against all the time. That's standard comprehensive general liability is for negligence. An interesting question is to what extent can you insure against willful misconduct? And it turns out to be complicated, although there's some sense that we don't want to encourage willful misconduct by allowing insurance. So then the question becomes, do we treat this decision as to kill or injure somebody in order to save the life of somebody else in the situation? Do we treat it as deliberate misconduct? Do we treat it perhaps as murder? Not obviously on the part of the car, but on the part of that, versus either possibly criminal liability on the part of the designers and the corporation, versus either malfunction, or you might ask yourself whether a sensible thing is some sort of no-fault regime where it says, it may not be malfunction, it may be proper function, but at least you should compensate the estate. So that, I think, is the real question more than the magnitude of liability.
So what is your best guess as to how this will play out?
So my best guess, and maybe this shows that I'm a technological optimist, is that driverless cars will be so much better, first of all, in being safer, even if the first generation is and the next generation will be. But second, in terms of the sheer amount of time and hassle and aggravation that they save for the drivers, where people can spend, if they're stuck in traffic for an hour, that is an hour they can either spend enjoying themselves or an hour they can spend working, that whatever extra costs, even in terms of punitive damages liability, car manufacturers bear, are going to be dwarfed by the benefits. So I'd rather buy this car, which is an expensive car with an expensive insurance policy, than have to pay my own insurance and buy for a non-driverless car and spend all of this time. And also my hope is that if there is a real concern, not about the ordinary everyday on safety, where the theory is, you want tort liability to try to deal with that and be priced into insurance, but the concern about this kind of vast liability because of the supposed wrongfulness of these decisions, that you're going to have some sort of statutory protection like we have for nuclear power, where the sense is that the damages would be theirs, not infinite, but at least very, very great, so we need to put a very high a cap, even if a very high cap. So I think that between the technological features and possible statutory fixes, I think that problem will be solved. But I do think it's useful to think about that problem because, again, you don't want a situation where the designers fear criminal persecution, perhaps, for making this kind of decision.
Which they do, by the way.
That they fear it.
Yes.
Yes, I think it's more hypothetical than real, but, reasonable people reasonably fear hypotheticals.
Before opening things up for questions, I'd like to ask one last question to all of the panelists, which is from your various perspectives, what is the role of the lawyer in advising startup companies, technology companies, making regulation? And a related question is, what can we as law schools do to better prepare our students for advising companies that are developing technology? Mike, could you take the first stab at that?
Sure. So I'll just speak generally about that, not with reference to crypto or blockchain, but I think the greatest value and the greatest role that we play with entrepreneurial clients is kind of saving them from their own, saving them from themselves, right? Very often, I'll have a client come in with a term sheet and say, I have to sign this today, it's of vital importance, and you stop and you say, hey, look, let's sit down, let's read this, let's talk it through, let's come up with a game plan, because very often, the client is so excited to just go ahead and get a deal done that they don't even think about what the consequences are. And I say it probably once a week, hey, you won't regret this today, you won't regret it tomorrow, but in 18 months, if you sign this, you're gonna come back to me and you say, why did you let me sign this? So I think that's a huge part in transactional practice, is just to play the devil's advocate with your client and try to slow them down, not to stop them from doing what they want to do, but to explain to them what the long-term consequences are, because they're managing for a very short-term horizon, right? They got to get this capital in. I think more generally in when we just talking about the blockchain space, the SEC has said, we are market participants. Lawyers have a special role here to play. We are members of the bar. We have a public responsibility here to a certain extent. And so we need to be very careful. And I mean, the number of projects I just say no to in that space because I either don't feel comfortable about the team or about their methods or about their plans is much higher than in other spaces. And so I think I think for a law school, it's very important that students have a really firm grounding on, what their role is as a member of society, because, so often you're like, oh, I got to build these hours, I got to get these clients, but you really need to, I think, take a step back and think, where am I going with this? And going back to the blockchain thing, I mean, one thing that really, I think, concerns me about decentralization, I think it's a fantastic technology. I think it is going to be life-changing. I think it's really remarkable, but you don't like fake news now. What about a system where no one controls it? You look at IPFS, which is Protocol Labs technology. Their technology was used in the Catalonian vote to circumvent censorship by the Spanish government. You can look at that as somebody who believes in small d democracy and think that's fantastic, or you can look at that as somebody who believes in the nation of Spain and think that's treason. And so as an attorney, you're going to be confronted with these projects that can be used for really great societal progress or could be used in the wrong hands for some very unintended consequences. And these decisions can be programmed into the protocols that you're representing. So it's something that gives me pause, I think, on a day-to-day basis when I work with these projects.
So my advice to attorneys is what I ask my company's corporate counsel to do for them, so I spend a lot of time talking to attorneys, is not just give them legal advice, but also share their common sense. So for example, when it comes to blockchain, I have 20 companies in my portfolio. 15 of them are candidates for selling something in the form of a token. And I ask myself, and I ask people who advise them to say, hey, listen, give them the legal advice, but also ask them, can you just charge money? Or or if you're issuing tokens, can you just and those people will buy those tokens, can you just exchange money? Or is there absolutely the likely existence of bad actors? So I understand, for example, in the case of central banks, you have dictators and governments that leverage currency to wage wars against each other, and or policy or whatnot. I get that, but if you're a rinky-dink startup, who, or even in the future, who would be the bad actor here, or why will there be a bad actor where you need a self-regulating, blockchain-like, technology, or would it be like Uber, which pretty much regulates itself? If I'm a bad passenger, or if Mike is a bad driver, there's a good chance that we'd be kicked out of that network, and there doesn't have to be crypto and hashing and blockchain or whatnot to regulate that. So.
And again, what's interesting with the SEC's position, to pick up on your point, they're saying only in the case of decentralization, which I happen to agree, full decentralization is scary to me. I would like some central authority actually kind of overseeing a little bit. But they're saying, oh no, only in that case the government won't take a view, at least from a securities law perspective. So, but in terms of practicing, you need a high moral bar, and you have to stick to it. We disengage with clients when we think they're about to go off, in a direction that we feel is not appropriate. And those are hard conversations to have. Many clients will change their mind based on that fact. They test you, don't you? But I agree, you do need to give practical advice at times.
Cooley is our fund counsel, by the way, so.
So, great. Oh, yeah, we're always giving out business advice. So, but yeah, I mean, sometimes you just have to use common sense, and I rely on my gut a lot, and, stick to it.
I wanted to mention two general things, one of which is it's a much bigger picture thing. There are some students in the audience.
Yeah, of course.
So just for the benefit of students, here's one way of thinking about things. Back when I used to teach tort law, I would teach trespass and nuisance, briefly, but I taught them some. And so if you recall, here's the rule for trespass. If I step on your land, or if I throw things on your land, even not deliberately, maybe I fall, maybe let's say I have some stuff on my property that is launching pieces of gravel as a result of drilling or whatever else.
Rolls down a hill or something.
It does, and especially if it's something that's not just especially if I know it's happening and I don't stop it. Then in that case, that's trespass. You don't have to show damages. You don't have to show substantial interference. So long as anything falls onto your property, damn it, it's yours. So then there are interesting questions. There was a case in Nevada a couple of years ago. What if somebody maybe deliberately projects light onto your property? Common tactic for unions to project like images of rats or other things onto the side, in the evening, of course, in the side of buildings. Is that a trespass? So you could say, oh, well, that's an interesting question. Is it a thing or is it not? Is light a particle or a wave? There's actually an opinion by Judge Jerry Tao that talks all about this. So you might say, oh, that's interesting. Let's try to use these physics concepts. But here's a rule. Odors do not qualify as trespass. They might be a nuisance if they sufficiently seriously interfere with your property, but they're not a trespass. You ask a physicist or a chemist, this is like little particles of gravel, right? They're I guess, esters and this and that. But in any event, there's no doubt whatsoever to scientists that smells are stuff. You can debate light, but smell without question is stuff. Now, of course, if you think about why the legal system operates this way, it's because otherwise things couldn't function. You couldn't have a barbecue in your backyard because every neighbor who smells it could say, ooh, I'm smelling it, therefore some of your particulates have gotten into my property, therefore this is trespass. Life in society couldn't function this way, as opposed to with bigger stuff where, you're expected not to let bigger stuff fall on other people's land. So one of the important points is the law draws lines. The most dangerous thing is when it draws lines that sound like the lines that the scientists or technologists or business people are familiar with, but it actually draws them in a different place. So one of your jobs as a student, and this is of course what everybody on this panel is familiar with, is of course you need to translate the science or the business or the technology into the legal terms so you can persuade the legal regulators that what they're doing makes no sense to the business world. But you also have to translate the legal concepts to your tech people who being people who think highly of science and technology say, well, our rules are the right rules. Your rules are obviously, they're illogical. I'd say, thank you very much, Mr. Spock. But the rules are made, they have their own logic, but even if the logic is unsound, and if it's more tradition than is really called for here, that's the way they are, and don't be deceived into thinking that because you organize some relationship as an independent contractor relationship, employment law will recognize it as that. Don't be deceived into thinking that because you've organized it in a way that doesn't look like a securities offering to you, securities regulators would do that. So that's just one important point. Your job is in many ways in this situation as a translator. And with regard to your client, it's also somebody who can win their trust and can persuade them, yeah, I know you think that you're absolutely right. Within your domain, you might be absolutely right. But trust me on this, the law sees things differently than you do. The second thing I wanted to echo something that had just been said, though, is that whenever you can find a way to make the technology avoid the problem, the legal problem, that is almost always the cheapest solution. Let me give you an example from VR. There was, you may have seen, there was an article some months ago about virtual groping. I'm always skeptical about virtual because somebody once said about quasi in the legal context, quasi something means not something. Right? So virtual groping, I think, is not groping, but it's also apparently not pleasant. So here was the scenario. This woman was writing about how she was playing, I believe, Quiver, which is a virtual reality archery game. And there was another player, it's a multiplayer game, there's another player who came up to her and then started visually, it looked like he was groping her breasts. Now, of course, he wasn't actually groping her breasts, but she was quite perturbed by this. I don't think she was saying it's just as bad as actual groping. She was saying it's bad, and certainly if the goal of the game is to give players an enjoyable experience, you don't even want to know, can I insure against possible assault claims? Are there going to be assault claims? You just want the problem to go away. And in fact, the coder said, we never even thought about this, but now we've set up an option where you just push a little button and there's this bubble that is around you. And then either from everybody's perspective, or at least from yours, nobody can come within 3 feet of you. Technical solution, it solves the legal problem by just not giving a legal answer, but keeping it out of court. Another example is, in the article we talk about what do you do about disturbing the peace. What if somebody is shouting super loudly in a virtual reality environment? What do you do about indecent exposure? Is it a crime, or is having a naked avatar, is that like being naked in public, which is a crime? Or like showing a picture of someone naked in public, which is protected by the First Amendment? Really interesting question. Our claim is it probably won't even come up much because technologies would, or at least should, say, okay, here is a button you can push to silence somebody. And so if they're shouting, you just push this button and they're not shouting anymore. Or there's a button you can push to take their avatar and turn it all blue. So whatever naughty bits they may be showing on this, it just becomes kind of something enough that you can see that there's an avatar there, but you just don't have to see it. It doesn't matter if they're naked or if they're displaying a swastika or if whatever else. The technology can often keep the legal problems from happening. Often technologists know this, sometimes they don't. Sometimes the lawyers can help them see it.
That's wonderful. Any questions from the audience? Yes, sir.
So this is on the topic of autonomous vehicles and back to that prioritization problem that we have on which lives are prioritized over others. You might have seen the article that came out of the MIT Technology Review Journal last week, which showed that survey data across the globe, 2.4 million respondents over 4 years, says that the priority levels are different based on which culture you're in. So in the United States, which is an individual culture, young people are prioritized over old people in that trolley problem scenario, whereas in Japan, old people are prioritized over young people. Because cars are manufactured in both Japan and America, and there are different regulatory bodies covering those companies, do you think this issue is going to be dealt with on a country-by-country basis, or is it going to be an overall international decision that's made? I mean, what are your thoughts on just that problem?
Tough one. You would have it.
Oh, is it tough?
I mean, I
No, go
have
on.
no knowledge, but I mean, look, we in Japan they drive on the opposite side of
Right,
the road as well.
right,
I mean, it's,
right.
I mean, it seems like it's a fairly easy. It's a button. You just press a button, and now in this country,
Right. I mean, you have to do it not just by country, but by every neighborhood. You have to have a different speed limit that the cars abide by. It seems quite clear that they ought to
Yeah,
have
they
those.
do abide by them. There are so many traffic jams in Mountain View because as they were
About it too
testing
much, yeah.
in LA, you guys will go nuts with these.
in
I'm
labor
telling
law.
you.
In labor law, I think this is known as work to rule, right? Where union members try to sabotage the employer instead of just going on strike. They just follow all the rules all the time. But so let me just mention. So first, so without question, you just follow the rules of the country. It should not be hard. But second, this is an illustration of the point that you have to understand things from the domain of the researchers and the domain of the law. So here the researchers are the survey takers, and it's very interesting information to know that many people think that it matters what the age of the parties are. My guess is that if my car had a rule that says, especially let's focus on me as the actual customer of the company, we will save your life if you're under 30 more quickly than we will save it if you're over 50. That is almost certainly prohibited discrimination, at least under some state laws, in basically public accommodations, more or less, because some states provide goods and services. And certainly it's the sort of thing that would be reluctant to try to explain to a jury, because while some jurors might buy that, others might just say, oh my God, this is age discrimination. Don't we know it's somehow wrong, even if there's no specific statute? So I think this is a very interesting study to have. I'm glad that they're doing it, but one of your jobs as a lawyer is to tell people, maybe as a matter of technology it works, maybe as a matter of kind of maximizing positive public response even, that kind of technology, the technology of public relations, it works, but it may not work as a matter of law.
Yes, there in the middle. In the blue shirt?
Right,
Yes.
right, exactly. A new reason to lie about your age.
Thank you for your time. So with regards to ride sharing, I'm a pretty avid user. I'm not very optimistic on the future of autonomous vehicles, but a left turn, some people were laughing, so they probably knew what I'm talking about. Almost unanimously recommends a left turn onto Wilshire, onto Pico, onto Olympic, where there is no light. And if you're not familiar with these streets on the panel, these are essentially like highways.
Yeah.
And a human being whose brain is infinitely more cognitively sophisticated than any computer within our generation will be, out of habit, tends to follow that direction and make a left. At which point I usually say, excuse me, if you want to make a left on this road, I will get out of here. Because you do not want to be making a left on this road. 9 times out of 10, they're not from this part of town, so you're not familiar with it, and they're just kind of roboting away, looking at whoever the GPS provider is. That's kind of more of a comment, but I'm curious, to your knowledge, have the navigation providers been sued on this point, and what would be the legal issues around it in terms of, if they were to follow the navigation's advice on should they make a left, or should they do like UPS does and always make rights?
So the scenario that you are describing, in my opinion, others may disagree, will never come to fruition in at least my lifetime, or anybody that I know. What you're describing is a level 5 vehicle, a vehicle that can pilot itself under any circumstance and is basically driving off of a third party's, in this case, it would be a navigation application's directions, correct? I would not even worry about that. If I was a mapping company, I wouldn't worry about it because I wouldn't expect an autonomous vehicle to exist in the next 100 years that would be piloted in that fashion. Autonomous car companies today are aspiring for what's called level 4, which is a vehicle that can operate within a finite set of circumstances and geographies and conditions. And these vehicles are programmed on routes. So if this vehicle has not traveled this route before autonomously, it probably won't attempt that left turn onto Pico that you're describing. So autonomous cars will be programmed on routes, and those routes over time will increase, and there will never be situations, you will not be in a situation in an autonomous car that the vehicle is trying to traverse some terrain or some situation that it hasn't encountered before. So what you're describing, in my opinion, is a very, very unlikely situation. Again, in our lifetimes, maybe in 200 years, sure, you'll have a robot like that Total Recall. You'll have a robot behind the wheel or the equivalent of that, and you're shouting at it, turn left, turn right, turn left, and it does whatever you say. But I mean, that's just a quantum leap ahead of what I would ever expect to come out of technology.
And if there is a light, it'll never turn on the yellow light. You'll be there forever.
My concern and question was more in regards to the way it's being operated now.
So it's interesting questions, but it's just a reminder of about one factor about the tort system. So you didn't indicate what happens when he turns left. So if he turns left and gets hit, then it's an interesting question of whether the recommendation was unreasonable. It's not clear to me that it is unreasonable, precisely because since it's legal to turn there, that suggests that at least under certain circumstances, many circumstances, it's reasonable if traffic conditions allow, and in fact, most of the time they do, and sometimes when they don't, I'm inclined to say it's the driver's fault and not the mapping software's for not recognizing the traffic conditions. The real problem isn't that he gets hit. It's that he sits there for a long time, wasting your time, tries to turn left, then wastes your time, because you were talking about some of the consequences of this for traffic patterns. And interestingly, one feature of tort law is I can't sue a manufacturer for slowing down traffic so much that it wastes me 50 hours a year, even though my 50 hours a year might be very valuable, because you can't sue for interference with business relations or interference with income capacity and such, generally speaking, absent damage to person or property. So that's an interesting way in which there's an interesting discontinuity in the legal system. That as to the rare thing, which is the accident, there are these rules, and they will probably immunize the mapping software. But the really interesting thing is one way in which something can cause societal harm isn't by causing accidents, by causing slowdowns and the like, and that's something the tort law system may not be responsive to.
I know there's more questions. I wish we could talk all afternoon, but I know people have to catch flights and get back to work. Joel, did you have any final announcements?
Thank you, everyone. Very much appreciate your time.
Thank you so much.